Now I am inviting to this call a person who responded to our request. So I will tell you that I was looking for legal support starting from the end of 2023 because, well, legal aspects, let's say, of American law, I am not familiar with it. It is specific, and accordingly, help from competent people, lawyers, attorneys, photo companies, and so on was required. So I conducted countless negotiations with American lawyers. Naturally, we were limited in terms of language and it is very difficult to work only with American-speaking lawyers, so I was naturally looking for those who had specialists for Russian-speaking clients. That's all the applications that, well, I found. I sent them to the chat, they were all paid up front, so to speak, and they didn't suit us, especially because the costs each participant would spend interacting with this lawyer, mathematically and economically, would ultimately be more expensive than recovering these funds. And as I already wrote, luck is on our side. I was fortunate to meet Sergei Hrabrycha, to whom I explained what our case was about, what our task was, and he responded with terms that one could only dream of. Well, that is what we actually wanted. So we sent a request to the universe, and such a person with his human rights organization, ARGA, was found. Sergei?
Good day to all participants. More people are joining. The crowd is growing. Well, Yevgeny, our pause has been a bit long so as not to keep people waiting too long. So I will start briefly with an introduction about myself, about the organization I lead. I am not alone. My name is Sergei Hrabrycha. I lead the French Human Rights Association, a complicated name, Asylum Research and Global Assistant, ARGA. We all call it abbreviated. So the association is already 3 years old. The main directions until last year were international protection. We interact directly with the General Assembly of Interpol. This is an organization that makes amendments to the Interpol statute, constitution. So it is not the headquarters, but we prepare statistics for them. Scientific research regarding offenses in the Russian Federation, in CIS countries. These days, we are finishing a big film with the BBC, a documentary precisely on this topic. Separate interaction with the United Nations from the point of view of human rights protection. And since last year, more than a year ago, minority shareholders of the Lebedinsky mining and processing plant, ordinary miners, approached me. So they fought for compensation for more than 17 years. In 2007, the shares were bought out. Only in the Russian Federation is there a law that majority shareholders have the right to forcibly buy shares at a price they consider acceptable. And generally, the initiative group fought for a long time, lost all courts in the Russian Federation. It should be said that the owners of this Lebedinsky mining and processing plant are Alisher Usmanov and Andrei Skach, well-known people. And currently, we represent their interests with a claim in the High Court of London. We have good colleagues, partners, barristers there. We get support at the level of government structures. It is a big, high-profile case. In the United States of America, we are conducting several cases. Unfortunately, I cannot disclose their details and nuances, but this is connected with asset protection from there. We recover from funds previously frozen belonging to or still belonging to the VTB Bank, Russian. There is a very large amount of money in one state. And thus, when we are on familiar terms, may I? Yes, Yevgeny. Yes, of course. Yes, when I heard you, saw this appeal, well, this is actually called an opportunity. So we already have colleagues there. There are quite well-known lawyers and attorneys in the USA. There are, I know that our case will involve lobbyists at a high level. That is, well-known people. And in the USA, lobbying is not prohibited. On the contrary, it is welcomed if it is on a legal basis. So the composition of my organization includes lawyers, attorneys in the European Union. We are also represented, there are divisions in the Arab Emirates, there are divisions in London, and we have our representatives in the United States of America, not divisions, but representatives. And when I started dealing with this case, the first thing I noticed was that basically there are arrests, the investigation is completed, there are verdicts. Therefore, in principle, if at the moment we can consolidate all efforts, gather as many applications from clients as possible, then we have good chances. Moreover, we operate strictly within the legal framework. I have good, close contacts with journalists from the BBC, New York Times, Bloomberg. Yes, but here it is important to understand the agenda. That is, of course, I will negotiate with everyone to attract media to this case. Well, in principle, in my understanding, this is a working case, absolutely, not complicated by bureaucracy. We understand. And in addition, unclear, well, official, public statements by the new president. Yes, that reserves will be formed from cryptocurrencies. So there is also this moment, but this is actually more on the level of conjectures. In the USA, the law works. The law is the same for everyone. So if we properly formulate and, most importantly, break down into stages our applications queue, that is, we will not wait until everyone gathers or the majority, but as you suggested, we will break it into stages. The first stage, we will now collect the first clients to already make a move, and then people will join. We expect success, in my opinion, in 6 to 12 months. We already discussed prepared agreements, prepared applications. That is, we go at our own expense. That is, repeat once more, opportunity. We are already there, and we are already conducting quite large cases there. So in this case, there are no secrets. We are already there and working. And the success fee we talk about assumes only a percentage of recovered funds. That is, at the moment of transfer to each client. There is no trick. On the contrary, everything is extremely clear and understandable.
Yes, these are excellent conditions. Well, many people who contacted me said that if there was such an opportunity, that is, no upfront payment because there are no guarantees, unclear whether the money will come or not, return or not, they do not want to invest more. Yes, and many are in such a situation that they have nothing to invest. But if money is recovered, then people are ready to pay for success, so to speak. Good.
Well, people have already lost trust, so I propose, as we discussed, to simply give dynamics to the cases. First form, move forward, get the first responses, get the first results, and then people will believe again. That is, better than any words, in action. Why did we limit applications acceptance until June 7 for the first wave of victims? I suggest, Yevgeny, to move to questions so people do not fall asleep.
So we prepared about 30 questions. So if 1 minute per each, that is 30 minutes. Zai, yes, we will try. Try to be quick. So the first question, what is happening with the AirBitClub case at the moment?
Club case at the moment? From the point of view of papers, documentation. So from the point of view of documentation, at the moment, the ARGA Club case is considered in the USA as part of sentence for case number 20-ST398 in the Southern District of New York. The key figures are already convicted, including Dos Santos, who is the main organizer. Assets are confiscated, and by court order, a compensation phase is already appointed, called restitution. Well, this is in French and English, restitution, basically the same. So our task is to properly form applications in the right way, contact all structures without violating sequence, subordination, get responses, and thus wait our turn to receive funds.
Okay. So second question, who is officially recognized as victims in the case?
So victims are recognized absolutely all persons who invested funds in this scheme regardless of the period, in the beginning, middle, or end, regardless of country of residence. That is, if someone has the impression that there is a geopolitical factor, it is not considered at all, including ongoing, well, let's say, changes in the sanction regime. They do not affect anyone. Accordingly, the only important thing is evidence. If evidence exists, but evidence can be either logical or documentary confirmations.
Yes, this leads to the next question. What applications can be accepted if a person, for example, does not have screenshots, receipts, correspondences, confirmations? What should such people do?
So in this case, well, it happens. And according to American law, a letter of registration, login, account ID, or witness testimony is not enough. That is, if, for example, people cohabitate and say a spouse performed these actions, then witness testimony. But the only important thing is that there must be at least 2 such witnesses. They must be written, composed in the native language, but translated by a sworn translator or with an apostille, differently called in different countries. That is, witness testimony must be properly executed according to U.S. requirements. Thus, all people who can confirm, here are logical explanations, non-documentary, can also claim their applications will be considered.
Uh-huh. But overall, you answered also what evidence is considered minimally sufficient, so you listed all this. Let's move to the next question.
I apologize, one more point. Even concerning witness testimony, for example, well, suppose many people and suppose someone lost absolutely all means of confirmation. No screenshots, no proofs, but maybe when using, he, conditionally speaking, logged in through another person's device or personal computer. There is access. This is also evidence. I just supplemented the formulation for full understanding. That also happens, and basically it is evidence too. Sorry, Evgeny, interrupted.
Uh-huh. No, this is a great addition. I can also add here that many people contacted technical support, but before that, they probably contacted people who invited them. So raise all these correspondences, guys. Look, in any case, you sent some screenshots, something did not work, and all this will fit. So everything you find, just allocate time, attach everything, and your package, your case, will be formed individually.
Yes, it is very important to understand that at the stage before court decisions were made, that is, at the investigation stage, there was a need to contact technical support. Technical support was temporarily carried out by the temporary administration, that is, after the arrest. But now we are dealing with the U.S. judicial system essentially and follow the U.S. Criminal Procedure Code. That is a different story. Here, technical support will not help, yes, which simplifies the task, so to speak, in our case.
Okay, is there a deadline for submitting these claims?
At the moment, no deadline is announced, but it is still recommended to submit an application by the end of June. Try to get into the first or second wave. It is not that there is not enough money for everyone, it is that, as in any state, there is a huge bureaucratic apparatus. And, considering that there are many participants, individuals, it is easier with a company, that is, conditionally one legal entity and a large amount of money. And from the point of view of paperwork for U.S. authorities, simply the further the queue, the longer it will be considered, since this is a lot of, well, let's call it bureaucracy, yes? With each client, you need to form, sign, reply. So the sooner we stand in line, the sooner we will receive. But all will receive, of course, since confiscated money is sufficient. So these fears are better to be immediately removed so that people do not create unfair hype.
Uh-huh. Okay. What assistance does the ARGA Association provide to victims of AirBit Club, if possible, in detail?
So we help, well, at the moment we have several people. Our main ones are Ekaterina, Ksenia, well, people who will interact, get acquainted with them. So the first thing we do is help to compose an application and check it. Well, mistakes happen. People make mistakes. We check, translate it into English. It is important to understand we will have to translate from different languages, but we translate into English. We take care of this too. We help collect the logic of evidence. We have already published the main requirements in the application, but there will be individual cases where people will still need guidance. Yes, we understand that it is not every day you have to recover money, return it, and so on. We take this work upon ourselves. Accordingly, we represent the interests of clients in the USA at all stages. Today, we assume, that is, I, at least as the head of the organization, assume a long route. Yes, as they say, it is better and easier to proceed from the worst-case scenario than in life it will be easier. Yes, movement will be easier. Most likely, we will take the long way through all instances. Here, it is better to overdo than underdo. Accordingly, all related costs for lawyers, representatives in the USA, we take upon ourselves. This is written in the agreement, so all obligations are formalized in writing, and thereby we guarantee all clients that no additional payments or costs will appear during the process. We agreed, signed documents, moved forward. We take care of everything.
Uh-huh. Excellent. So in which jurisdictions is the case considered, and who handles the return of funds?
At the moment, in the USA, CIS, and let's ask Maxim after the broadcast to pin literally all links, all abbreviations, we will pin them. The case covers dozens of states, dozens of countries. Official sources currently say that about 3,500 bitcoins are arrested. Not 2, but 3,500 bitcoins. Fresh information. At the moment, the procedure is handled by the U.S. Dodge Prosecutor's Office, and there's a separate order for Rion Office, an organization, a division that deals directly with the realization of confiscated funds in the USA.
Uh-huh, good. What is the role of the ARGA Association in this process?
ARGA acts as a human rights structure. Well, there is a human rights structure. By the way, I get many personal messages, questions, and we already prepared templates to check the status of the organization in the EU, especially in France. There are official government sites, official state journals containing all information about operating organizations in government registries, the goals, mission, tasks. So we act as a human rights structure. We have the right to do so. The only thing is that when it is necessary to represent interests or appear in court, here, lawyers certified under U.S. laws front us. Accordingly, here we act as representatives of victims, ensuring coordination between victims and U.S. authorities. So basically, we act not as intermediaries, but as representatives. Yes, we have a representative function. Plus, according to the contract, our task is to hire lawyers on behalf of the client, and accordingly the fee and so on, we take on the entire complex. All this is written in the agreement.
Uh-huh, okay. I see some questions I wrote are repeated in different contexts. Let me read all, because if someone asked, it is important to them. Even if we discussed it, you will answer again. Uh-huh. Are there chances to get compensation if evidence is partially lost?
Yes, we talked about this above. Chances exist. The main thing is sequence, logic of description, how it works in European law and basically in international law. This is briefly. In post-Soviet space and CIS countries, there is a notion that if there is no evidence, you won't be considered. In European and Western jurisdictions, even if a person lacks written evidence, their account, especially if supported by witness testimony, is grounds. Because trust level to applicants, I won't highlight only France, all Western countries, is much higher than in CIS countries. It is easier here to prove the truth. If a person, well, in the understanding, in the logic of justice, comes legally competent, makes a written statement, and tells the story, they are believed. I repeat, there may or may not be, but better spend time, think, remember maybe some screenshot or message and so on, any information trace. It will be easier in this case, but basically, a written account will be accepted if translated properly by a sworn translator or with an apostille depending on the country and law.
Uh-huh, okay. Sergey, there is a rumor spreading that American justice works only for Americans, and many victims are not in the U.S. or are not U.S. citizens. How should they file abroad?
Of course. If they are not citizens, absolutely yes. It is a transcontinental investigation. Official sources say U.S. allocated investigators and conducted investigative actions in dozens of countries. This is an international case, international fraud. So from absolutely any country you can file. The main thing is to comply with the regulations we already reflected in the application. And there are no problems from any side.
Uh-huh, good. What is the role of the ARGA Association in this process?
First, we consolidate the statement, send it. After verification, compensation will be distributed through authorized bodies. I already said above. This is restitution, a government structure that deals not only with our case, but generally with the distribution of confiscated funds, payments to victims. Accordingly, it may take several months. I repeat, a lot of paperwork. And considering that registries have already been formed, they are huge. But each case in the list is important for executors. They must report literally on each victim. So it takes a lot of time to give attention to each. The problem is, whoever stands later in this queue will get paid later. But all should receive based on confiscated funds budget. There is enough for all our clients and others.
Uh-huh, okay. I put the camera a bit.
One moment, Evgeny. If people are interested, there is a delicate question. I received some personal messages on this topic. People fear fraud and assume that according to the approved mechanism, first ARGA gets the money, then they get theirs. This is not so. We sign the agreement, and at the moment of funds distribution, money for our clients comes separately. By procedure, we will never be the recipient of the entire amount and then the sender. Yes, we discussed this. Because in my opinion, the biggest difficulty today is to restore people's lost trust that this is generally possible, and secondly, to defenders representing their interests. So we form conditions guaranteeing each client so that even if they think, what if you take our money and do not return? No. Our mechanism is built so that the person immediately receives funds directly.
I will note that for some people, I will not say quantitatively more or less, but for some it would be more convenient if you acted as an escrow account, so the money goes to your account and then you pay them from your account, because many live in countries under sanctions and cannot receive directly, so this option, which you reject, would be better.
Yes, Yevgeny. As promised, we will think with lawyers. Consult. I am based on transparency principle. If people see transparency at the beginning of relationships, they are maximally guaranteed. Then I am calmer and they are calmer. I will note about myself. But let's return in the next stream. We will prepare a solution so it is fully, I understand what is meant. People worry they will not receive in Russia. This can be arranged. The only thing to advise is so we don't violate anything or get in trouble. But mechanisms exist. We discussed there are legal, lawful mechanisms. We will think and convey separately for this group of people. Convey mechanisms separately.
Okay, good. In general, I agree. The most common question is about guarantees. What guarantees exist that money will be paid, compensated?
First, we deal with the state. The money is confiscated by the state. Assets are already arrested, evaluated, well, not weighed, but evaluated. Official sources say 3,500 bitcoins. This is a very impressive amount. They are under state control. So once we prove legitimacy, once we properly prepare documents, payments will definitely be made. I return to the hardest moment. Considering many physical victims besides us, our clients, and for Americans a lot of paperwork, this will be the difficulty. There is uncertainty in terms. I find it here. It will be physically hard to process so many claims. Overall, guarantees exist. Guarantees of the U.S. government. So I see no difficulty here at all.
Okay. Regarding timing, how long can this procedure last?
Today, based on a weighted average, we talked with lawyers. There is a small detail, a small oddity. We talked to defenders from other similar projects. Everything is much faster there, and for some reason, people get notifications, but we do not. We will clarify. It may be due to suspicion of fraudulent actions. I am just thinking, this is not a fact. I just came to this conclusion after talking to lawyers in the U.S. Either something was violated in the procedure, but notifications should come to us or through us. We will try to arrange so that contacts of all clients are indicated, so each could get notification directly. Currently, 6 to 12 months, forecast is from half a year to a year.
Optimistic timing, I tell you. If it happens within a year, I will be very happy.
We based on similar cases. I got 3 big consultations, broad consultations from there, surprised why it takes so long. We have what we have. We will understand on the way, will not understand until we start, then something will appear, something will clarify. Why? Because I repeat, it is not a fact, but I was told it might be related to actions of fraudulent groups inside clients. Something might have caused suspicion. That is an assumption. We will understand as soon as we start. From the first responses, we will immediately know. We will notify all clients directly so they understand what is happening and how.
Okay. Is there a known position of the U.S. Prosecutor's Office on priority of claims payments?
Yes, claims from real victims are prioritized. A real victim means, well, evidence volume. Must note there is human factor. The more weighty the case, the better. If an official takes a case backed by evidence, screenshots, contract, etc., it will be processed much faster and a decision will be made immediately. But legally, all applications are equally prioritized. According to U.S. law, these are priority applications. So here we must conduct paperwork correctly, not break the procedure, and secure support from their side. We have strong lawyers, attorneys, not in the sense of being big and famous, but they know procedures well and effective solutions, short, effective ways. Because the U.S. legal system is very branched, complicated, from state to state. Good specialists understand details, nuances of maneuvering. Let's call it maneuvering in legal base.
Yes, yes. Are there any risks for applicants submitting the claims?
Absolutely not. The only thing is we use this chance to warn people from the start to understand what blockchain is. There are less than 100 people watching now, people who at least understand blockchain on an average specialist level. Blockchain remembers everything. They say millions of years. So be honest, transparent. Sometimes a person lost, say, 0.18 Bitcoin, but writes 0.36 thinking no one will notice. Blockchain has all marks, and they have cybercrime specialists. They have their ledgers of confiscated assets, and they will compare the data they formed during investigation with what we will provide. They have marks, timestamps, IP addresses. They will quickly determine the amount. So do not fantasize when forming claims. Write as is. Very important.
Yes. I will add that they probably seized the AirBit Club database itself, all accounts and so on. So at least they will verify IDs, emails, verifications, and so on. This will be cross-checked. So you cannot come as a random person and say, I have no data, but I lost money, return it. It won't work.
Yes and no. Many applications, someone will err, but they will correct. So I would say, time passed. Better shift it.
Good. What documents will clients receive after submitting claims?
First, confirmation from us, official confirmation from ARGA. Then, when we send applications centrally to the restitution office, we will also get so-called acknowledgments first. An acknowledgment is an automatic response that your appeal is accepted. We will immediately inform here. Then we will receive addressed legal responses on applications. So it is good we have a general chat, a general group. Accordingly, any information, even acknowledgments, is important. We will inform about automatic acknowledgments, inform people on the process. Confirmation from us is an official document with ARGA's obligations, of course. And later, second, third stages, and so on, we will send all documents.
A question on data confidentiality. Who processes forms and what steps do applications undergo?
The first processing is with us, but we do not have competencies like Ryan Office. We check general data. Our task is to help people form more complete forms and collect evidence. Because we speak now live, but it would be good to physically verify paperwork. Human factor matters. Then they go to Dodge through representation. There they check, probably correlate, and synchronize with databases formed during investigation. But that is right. You are absolutely right. They probably have the ARBIT base, so they verify and then send to Ryan Office. According to our agreed strategy, we will use a fan sending. That is, we will notify several U.S. bodies immediately. This increases effect. It does not discredit us. It is legal. More reliable, so to say. Then we will see feedback. Who replies faster, better quality, we will rely on that.
Next question. What is your lawyer team working on this case?
We have an internal team in France, colleagues in Spain, and others well-versed in international law. I repeat, AirBit Club investigation is transnational, international. We have representatives in the USA. After the first stage, I will definitely invite them, introduce clients to them, give opportunities to ask questions, all important ones, so people can clearly know, understand, check online, and so on. Our motto, transparency. Ask about lawyers' reputation, qualification, competence, and we will consider going live 30-40 minutes as questions accumulate, invite our U.S. representatives to answer briefly and clearly. Live communication is very important. People see the person representing us, the person protecting us. Trust is now our priority, restoring people's trust. I see it even harder than legal actions, restoring trust.
Yes, you are right. Many times in 5 years we had scams offering fake refunds, private messages saying, I am lawyer, your money is in a bank account, let's start. tried to scam us. I don't recall someone actually scammed, but they tried, really worked on our group. Terrible. Uh-huh. Next, can one participate through a representative? I don't quite understand this.
No, I explain. Life is life. Time passed. People are adults. Someone died, so it happens. Someone can't represent their interests personally. Relatives, friends, maybe. This is provided. By power of attorney or other grounds, we can consider individual cases. The question: we would accept any application. No point forwarding one without documents. We will advise how to legitimize a power of attorney, notarize it. Someone died. Such cases exist. Unfortunately, much time passed. That's life. We provide a point in the form to represent by power of attorney. Could be relatives, inconvenient for someone, etc. Yes, possible. Not necessarily close relatives if connection is proven and power of attorney is of established form.
Yes, good. Does it make sense to request compensation if loss is less than 1,000 USD?
Yes, even loss of $100 or $500 is recognized as damage and is subject to compensation. Again, people have some small time costs, but 30-40 minutes, small time to prepare documents, send to us, nothing more required. So, principle, never leave rights unclaimed. Money also, we do not ask up front. People sent power of attorney, filled form, gave it, and received their, say, $300. Also money.
Question: how to declare losses when sending money in Bitcoin? Will Bitcoins be returned?
No, Evgeny, Bitcoins will not be returned. Amounts, damage is fixed in dollars. Court decisions, dollars. Return will be in dollars. We won't consider return in crypto equivalent, Bitcoin or else. Return is in dollars. Because criminal case, sentences, court decisions fix amounts in dollars. So USD. Yes, we will fix.
Then a question: some countries do not have dollar as payment equivalent. They have national currency. The ruble was 30 or 60 to dollar, now 80 or 90. What amount will be compensated?
Compensation will be equivalent. We return to discussion with difficult jurisdictions when people need rubles. Let's talk concretely. We will offer alternative ways, all legal. I propose, while discussing, you mark this question. Will be many like it. We will specify this mechanism in the contract. I marked this question to resolve with lawyers. Agree. Anyway, equivalent will be in dollars, no matter. Also, note some national currencies strengthen to dollar. People lose here. We will propose mechanisms. We discussed ruble DAWs, you marked, and other currencies too. In countries where dollar is not accepted or banned, we will come up with. We will involve our colleague Leonti. He is a good offshore trust specialist. Likely we will register offshore or trust for such needs. Legal forms allow beneficiary number 100, 200, 300. These entities created for specific purposes. We write in statute that trust or offshore is created to receive compensation from criminal fraud cases. We specify legal formulations, case status, details, aspects. This legal entity, trust or offshore, is created to transfer funds. Beneficiaries are victims. It costs small money. I must say expensive jurisdictions like Liechtenstein, Luxembourg exist, but many cheaper ones. Costs are small. When entity exists as a fund, we with Leonti, you know him, discussed, will set task, he will do it. After task completion and payments, entity is wound up with no obligations. Obligation is receiving money and distributing it to founders, beneficiaries.
You basically told how it will be.
No need to scare anyone. This should not scare away. Actually, if you understand legal nature of these structures, trusts, funds, offshore, there is taxation, but we don't deal with it. Trust is created. We form trust to receive money from U.S. Ryan office, pay listed 115 people with sums. When goal is achieved, it closes with no obligations or consequences. This is formed exactly for such tasks. We are humans. Sounds strange? Agree? Yes.
No, not strange. For me, this solves problem that many countries can't get money from USA bank account directly. Such solutions are great. We will find and have them. Which passport to attach? National or international? National may be in Cyrillic, Latin, or hieroglyphs.
Any valid ID or passport is accepted. We will translate videos into different languages. Valid ID document under national law of citizen's country. We will face U.S. bureaucracy, may require forms, may be accredited translators recommended. This is process, but we planned. I agreed. I repeat, very important, any ID according to national legislation of citizenship country.
Good. Will I get 100% of lost funds or only part? Enough confiscated funds? If all pay.
According to latest official data, 3,500 bitcoins confiscated. Considering number of victims and fraud amount found in investigation, stolen or lost due to fraud, money is enough with big margin. Bitcoin price rose. Even if falls to 80, 90,000 minimum, enough. So big margin, money should be enough for all. I repeat, don't rush. I have good example. I wanted to bring it in this stream. Friend calls me. I lost wallet password, 0.7 Bitcoin. Huge sum. Panic, hysteria, what to do? Must calm down. Good example, Shabbat, Jewish Saturday. They act wisely. Retreat, hand problem to God for a day, step back 10 steps, look from a side. Same here. Spend time, don't rush. Recall, surely there is a screenshot, SMS, any confirmation document. More confirmations of investment, interaction, more chances. We will fight for every case. More evidence, better. I say people must responsibly form claims. We will explain about witness testimony. Simple story. Acquaintances, friends who witness transactions, transfers, boast, I have. They write confirming that in 2019-2020, my acquaintance transferred money via such app. It will be accepted. Witness testimony in Western jurisdictions is strong evidence, unlike documents in CIS. So prepare carefully. Advice, we will fight for all. Doesn't mean we will reject anyone. We will collect and send. But chances are better with quality claim.
Specific case. Invested 10,000 USD. During AirBit work, earned 15,000 USD referral bonuses, internal currency, but could not withdraw any dollars. What sum to claim? 10,000 or 15,000?
Simple answer, only actually invested money can be claimed back. But one moment. From operational point, if person has record of interactions for a year, did 10, 15, 20 transactions with crypto, fiat, and had fixations, legal term, when profit was fixed, had opportunity to withdraw to fiat, thin legal aspect. We discussed with lawyers. We will prove. Fixation, legal basis is date, time that person had such amount on account, physically could use or withdraw it. In some U.S. states we will pass, in others fight. We will try, collect such cases, fight for it. Our lawyers are smart, good. We will try to break these sums too.
I add, no universal answer. Each case must be looked at. Evidence, situation, what happened, etc. If earned more, withdrew more, no loss. Remaining money in personal cabinet above lost or earned, U.S. government won't pay. Question about parallel project by Bit, Traxalt Pilken. Person bought Traxalt advertised by club founders, their project. Can losses on buying Traxalt or ICO participation be claimed?
Yes. All transactions, financial operations, all related to ARBIT Club, including side projects confirmed by investigation and involving organizers and accused, relate to one case, so included and will claim. We have full right for compensation per U.S. court indictment. These actions linked to organizers are fraud. Confiscated money will be distributed per each case related to organizers.
Similar question. I topped BitF exchange with crypto. This exchange was organized by these people. After founder's arrest, BitF website stopped. I lost access to crypto. Can I claim losses here?
Yes. Renat Rodriguez testified in court part of seized bitcoins are BitF client funds. Yes.
We will do a little differently. I must emphasize, Jen, that as a result of this work, after completion, we form interesting practice. Many precedents may have unusual cases. I talked to lawyers, reviewed unusual cases. Practice is interesting. Blockchain has legal practice and multi-level iteration. Project is multi-level, so we will face, but solve with interest and approach with interest. We take all cases, no easy ones only. We are interested, including development. What can be more interesting today than blockchain ahead of all? So we take all cases, fight for all, regardless of amount. Experience is important too. We have many young specialists, so we take all and fight for all. We are interested. Good additional decision. If we publish info from you in our group, if address changes, you send me message, I forward it, so everyone can click and see official or scam account to avoid thousands pestering you. Maybe a login on site and contract will be official and publish officially. Probably right way.
I can write myself, but many messages already. We will think. We pin in main agreement recognized contacts till court. I repeat, no risk. I strongly recommend clients check contract. Agreement text shows intentions. We think about deadline. I repeat, we'll invite U.S. colleagues who will work. We'll invite European colleagues so people see faces, names, verify online who represents, and when we reach end, so they know whom to send a heart on Instagram, Telegram. I am sure we will finish and result will be.
Someone asked, was cost of legal services announced? What percentage?
Yes, percentage is taken. I repeat, we have several large cases in USA. Why agreed? Not a miracle, an opportunity. When Evgeny proposed, we have such story, I agreed immediately because we already conduct 2 large cases. These are cases linked to large banking structures, Russians from Russian Federation. We cover all costs related to compensation, representation in all U.S. instances and wherever needed, at our expense. But by contract, we claim 25% of actually received funds covering expenses. Expenses are small now, but U.S. lawyers cost money. So, from received funds, we claim 25%. I repeat, payment mechanism does not imply receiving full amount, then paying client. We get our share at transfer moment. Money separated immediately, we don't keep others' money unless asked.
Okay. We are done with questions. Please summarize as a step-by-step instruction what a person who wants to start this process with your human rights organization should do. Steps, what to expect.
Briefly, first, make yourself believe it is possible. Second, try to remember, find confirmation, find as many screenshots, correspondences as possible. What seems insignificant is important information. Collect as much confirmation. If no direct evidence, no contract, but you are victim, we have Ekaterina, Ksenia, girls who speak Russian, English, French. They are friendly, explain to everyone. Our task, form proper forms as strong as possible to prove you are victim, not just someone near you. First. Second, fill simple form, sign agreement with us, also simple. Check. Most importantly, do not rush. If decided and trust us, spend a day or 2 more. Recall, get witness statements, form your dossier convincing. Simple evidence, witnesses, scans, screenshots, all important. I repeat, U.S. justice system trusts applicants, victims, more than CIS countries. Many examples where oral statements recognized victims. More evidence, faster process. You ease our work and increase chances. Okay, success. Evgeny, 89 or 91 people watched. We were long, whole hour telling, answering questions. Big enough broadcast. We should upload on YouTube. Many couldn't watch fully. Some watched 10 minutes then left. Some asked for recording. We have Spanish, Italian, Portuguese, Chinese, many language groups who want info. People communicate among themselves, will share link, info spreads fast. Good news spread fast. We want people to trust. We are open, I show face, our lawyers too. Not a shady office. Communicate on simple questions, weekly, 20-25 minutes. We gathered so many claims, sent there, now at such stage. Real-time info. People watch 10-15 minutes at 2x speed and understand. Suggest such 5-minute updates weekly.
Thank you all. Guys, we finish here. Wait news. Who filled forms, wait feedback from association. Who not fill, fill now. We set deadline June 7. Maybe extend to June 10 to launch first wave. But don't stretch. Need certain volume to launch. We'll accumulate second wave for few months. To declare, mark, process started, claim rights, don't rush to fix. People will join. Get in first or second queue, not 5th or 10th. Let's finalize by 10th, then collect next clients. All. Waiting from you, your team, and Sergey. Translated videos I post on Spanish and English-speaking resources.